It's coming up. We can see it, Roger.
All right. Do you see one slide?
We see
Uh,
one slide.
yes, sir. There you
All
go.
right. Here we go. Session two, capitalizing the company. Again, I'm Roger Royce. I'm a partner with Haynes Boone and Palo Alto, and this is part two of a series of 12. And let's just kind of start out with uh, the issues, issuing stock in a company. Last month, we talked about forming a company. We went through all the issues, choice of entity, etc. And we're going to assume that you're a typical technology startup company and that you've started as a Delaware C corporation. And I know that sometimes people start as an LLC, sometimes they start as an S corp or something like that. But 99% at least of the startups I work with are going to be Delaware C Corp. So that's where we're starting. So let's talk about the very first thing you're going to do when it comes to capitalization, and that's issuing stock to founders. I want to talk about how many shares, how the percentages are determined, what the contributions are, vesting and securities rules. So let's jump right into it.
Bob, Roger,
Yes.
there's a note here that you're not in full display mode. We can certainly see the slide. Is there a,
Okay, hold on here. Here's how we're going to do that.
It's nice
How
and
about
clear
now?
now.
How about now?
Fixed. Brad said it's fixed.
yep,
We're
fix,
good to go.
good to go.
Thank you,
Uh,
Brad.
you would think after all this time I would know how to use Zoom. Okay, let's start with a couple of definitions. First of all, and it's worth pausing on this so people kind of understand these terms are not interchangeable. They are quite different. And where it usually comes up when somebody comes into my office and they say, "Yeah, I want 20% of the stock of this company." And I have to ask, well, what exactly does that mean? Does that mean 20% of the authorized shares, 20% of the issued shares, or 20% of the fully diluted? So let's be precise, let's be specific. So let me define the terms. So authorized shares means the maximum number of shares that a corporation is legally permitted to issue. So when we form a corporation, this is one of those entities that it actually gets formed by filing a piece of paper with our Secretary of State in Delaware. And that piece of paper is going to have a couple of essential things. It's going to say the name of the company, and it's going to say your registered agent, and it's also going to say how many shares of stock and what kind of stock the company, the corporation, is authorized to issue. And it can't issue any more than that without going back and amending that piece of paper, that certificate of incorporation. So usually in startup land, I typically start at 10 million authorized shares. Sometimes you'll see 20 million. If it's not going to be a startup that hopes to go venture, we'll see less. But 10 million is where I like to start. And resist the temptation to start with some ridiculous number of shares. And I've had people that I could not talk out of it. They started with 1 billion authorized shares because, oh, gee, then they can give away, options on millions of shares. Look, you're not fooling anybody. You just look silly. Just stay with market and, don't get cute. Um, the other thing that you'll designate in Delaware is the par value of the stock. And what par value has nothing to do with value, absolutely nothing. What par value means, it's a legal concept. That means it's the minimum amount at which you can sell shares. And the way the Delaware imposes, it's almost like a Nigerian scam, the way they impose their taxes, because they don't have an income tax if you're not doing business in Delaware. But they do have a tax on capital, and they calculate it two different ways. And one way, the way we always use, because it results in a lower tax, is going to be highly dependent. And we're going to talk more about this later, but it's dependent on the par value. So you'll always see par value set at some ridiculously low number, like 0, 0, 3 zeros and a one, sometimes 4 zeros and a one. And that's because we don't ever want to violate this rule of selling stock below par. But more importantly, you don't want to end up paying a Delaware franchise tax, which is an entirely wholly avoidable tax in Delaware. That's authorized shares. From those authorized shares, the company is going to issue shares to its founders. Those are the issued shares. That's what actually represents ownership, shares or percentages of ownership in the company. Now, there's more art to science than this and more lore than law, but I typically start at somewhere between 3 and 7 million issued shares, depending on how many founders there are. Sometimes I'll get founders that want to minimize their Delaware franchise tax, even though it's only a few $100s. It will go higher than that because the way the formula works, that actually happens. And sometimes I get founders that just want to preserve a lot of flexibility and not have to go back and amend their certificate when they issue more shares later. So we'll start at the lower end of that range. And we will sell those shares to the founders almost always at par value immediately upon formation, because the only value the company is going to have is what you contribute to it. So we're going to contribute very little. Why do we do that? Well, primarily we want to keep that Delaware franchise tax low. We also want to avoid any tax issues that might result in granting shares to service providers. More later. And then finally, the third definition I want to pause on is fully diluted shares. When your investor comes along, or even maybe a later founder, and they say, gee, I want to have X% of the company, they're probably talking about fully diluted shares. That's not authorized shares. That's not issued shares. That's the number of shares that the company would have if all of its options, taken into account exercise of its options and conversions of its usually safes or convertible debt, exercise of its warrants, stuff like that. They want to know what they're going to get if you were to exit. Basically, if you were to sell the company tomorrow, what percent would they get? And that is a different number because on top of the issued shares, you're going to have these contractual obligations to issue shares in the future when you convert safes or people exercise options. Okay, so here is a tip. We're going to start with this as a sample cap table. And we've, in my example here, we formed a company, we've authorized 10 million common shares. So that's all that's on our cap table. Nothing's been issued yet. So now let's go through my example. Let's suppose we have 3 founders and we've decided we're going to split their shares equally between the 3 of them. They've taken my advice and did 10 million authorized, and we decided we're going to issue 4.5 million and reserve $1 million for later grants under our stock option plan to service providers. I'm going to drill down on all this stuff more, but for now, this is the big picture. So that's what we've got. Let's say we go ahead and issue the first 4.5 million shares, and we go ahead and reserve $1 million. We have a board resolution that says that we're reserving 1 million shares out of our 10 million to grant, for an option plan that we'll put in place later. So now what does our cap table look like? Well, here are the issued shares. Each founder's got 1.5 million. Remember, we've got that ridiculously low par value. So the purchase price is super low, and they each have a third ownership. That's on an issued basis. On a fully diluted basis, we look down there and sell F14. We'll factor in the option pool, and that changes our percentages. So we don't have a third each on a fully diluted basis. We have something less than that so that the numbers all work out. Okay, simple example, simple math, but I think it's good for us to level set and start with how these cap tables get started. And this is about as simple as it gets. It gets to be more complicated after that. Now let's start to drill down on some of these issues. So founder stock, what do founders get stock for? Well, according to the agreement, they're buying it. So they should be writing a check to the company if they're paying for it. But the other thing I want to do when we issue the shares is I want the founders, if they've been doing anything in advance, they might have some intellectual property. They might, and broadly defined, and we talked about this last month, might be a business plan, might be some technology knowledge, might be trade secrets, might be, diagrams, schematics, whatever it is, we want the company to own all of that. So remember last month, we talked about an invention assignment that every founder is going to have to give to the company. So the company owns all that stuff and not the founder, because your investor is going to insist on that. Well, I want to make sure that holds up. So, there's this concept of consideration in the law that when you transfer property, you get consideration in exchange. And you remember, and so we're going to recite the consideration here. You'll notice in this clause, $75 for the IP. So we make it sure it's just bulletproof. And then there's a tax concept here as well that you may remember from last week, and that's on formation, as long as the transferors as a group end up with more than 80% of the ownership, including its vote and value ownership of the company immediately after the transfer, then the transfer of property, meaning intellectual property for stock, is tax-free. That's why we say founder stock is issued tax-free. This is the operative clause that makes all that happen. And then we got a little bit of cash going into it as well. And this is the 351 rule, the tax rule that I just told you about. We talked about it last month. We don't have to dwell too much on it today. Now, I'm going through this quickly, but we're getting into more meaty stuff. So we all understand now, stock's been issued, founders, they put in a little bit of cash, they assigned whatever IP they have, if any, to the company. They've now got their stock. Before we got to that point, there was a discussion among the founders, and that was that uncomfortable conversation where the founders have to sit down and decide how to split up their stock. And, I'm just a lawyer, so, that's up to you. That's a business issue for sure. But I can help you with that. And I can tell you that there are a handful of different ways. And I actually have a very extensive presentation on this if you go look at the YouTube channel. But to summarize, today I'll just say here's 4 ways. The most common is just equal percentages because it's easy. And you'll find studies. There's a professor at Harvard Business School who's written extensively in Founder's Dilemma, I think is the name of his book, how if you split equally, you end up not getting as much value as you probably could have if you just look at the data. I used to believe that. I'm less convinced now because where you start out on day one is not going to look like where you end up on exit. You're going to have so many events for the typical company between then. You're going to add people, you're going to lose people, you're going to get investors, you're going to top off those grants. You might adjust those shares. So I'm not super stressed about what the percentages are on day one. And so I could be talking in equal percentages. On the other hand, if you think you're going to exit very soon, which everybody does, you might say, I want those percentages to reflect the value that we, the founders, are putting into the company. So one way is to do that through a formula. And this is what we'll call a static formula. It's fixed. We say, look, I'm working full-time, you're working half-time, I should get 2/3, you should get 1/3. That's a formula. And they get more sophisticated after that. Well, I'm putting in IP and that's worth X. And I'm putting in, you're using my dad's garage and that's worth Y. Whatever it is, that's a formula. And that's fine. You can, believe that you've got a more fair way. In my experience, the formula benefits the person who can pound their shoe on the table the hardest more than the person who's putting in the most value. So take that for what it's worth. And once you get to that point, you might say, well, maybe we should use what I call the Royce subjective method, where basically we just sit down and we have a long conversation and just kind of agree where we think reasonably we all ought to be given the level of commitment we're about to bring to the company and all the other factors, rather than running it through a very precise formula. Engineers hate that, of course, but that's how I would probably prefer to do it. And then finally, I want to give a nod to the concept of a dynamic split. And that's the idea that, you can, if you go Google slicingpie.com, you can see one example. And again, I've got a whole set of slides on numerous examples. But the idea is that you have a formula, but it changes as you go along. Because on day one, I might be gung-ho that I'm going to just give my all to this company. But by day 180, turns out I haven't given my all. And we need a way to measure that and to adjust my percentage up or down if we do that. I will tell you, there are some tax complexities to that that we can hack. Don't worry, but you have to be mindful. Okay, let's move along. to vesting. Everybody on this call probably knows what vesting is. In case you don't, what it means is it's the concept that people earn into their shares. So for example, if I'm a founder, I got a third of the issued shares on day one, and I leave sometime very soon, I shouldn't keep a third of the shares. That's going to totally mess up my cap table, make it really hard to get a new investor, to any investor to want to come in with all that dead weight on the cap table. So the idea typically in this valley, a 4-year vesting period is pretty standard. Sometimes you see 3, sometimes you see 5, with what they call a 1-year cliff, meaning that the service provider, in our case, the founder, doesn't really have any vested shares until he's there a year. And on that date, 25% of the shares are vested and cannot be forfeited if he leaves. But if he leaves the day after that, the unvested 75% will be returned to the company. The mechanism is that they're repurchased at cost, which remember was some tiny amount, but effectively they're being forfeited. He's losing all that value. How long? Like I say, 4 years for founders, 2 years for advisors typically. There is this tax issue I want to mention, that when vested shares are issued, I'll say it, but you don't have to understand it. The tax rule is that property that is subject to a substantial risk of forfeiture is not treated as transferred until that risk of forfeiture lapses. Okay, a vesting restriction is such a risk of forfeiture. Therefore, the property issued by the corporation is not treated as issued to the founder until the restriction lapses. When that happens, as the shares vest, stocks can be worth way more than 0.0001. And because they're service providers, they paid $150 for something worth $1 million or whatever it is, they're going to have compensation income. That's a really bad result in startups. We'll plan into that result. Public companies, we will never do that in a startup context. And the IRS allows us to make an election to treat the property as transferred on day one. That is the Section 83B election. And we now have an official Section 83B form. You can use your own that we can manufacture, or you can go on the IRS website and download their form and file theirs. It's got to be filed within 30 days of the transfer, or it is completely and wholly ineffective. You do it on the 31st day, it's meaningless. So we have to go back and fix everything, which is, no small task sometimes. And the biggest thing I want to point out about that is in my next slide, is that this is you, the individual's obligation. The company is, unless you get them to specifically sign up to it, they are not going to undertake that, because it's a disaster if it doesn't get made. So why would they do that? I mean, 20 years ago, company counsel always did this for every party. We all learned, that we do not want to undertake, that obligation to go chase, 100 or whatever it is, go chase people to sign stuff and send it back. Because if they don't, then they missed the deadline, it's going to be my fault. So typically you're going to find the company pushing this off to you, and you need to make sure this gets done. So just a word to the wise. Now, sometimes you can get the company to specifically undertake to do it, but this is the standard language that's in probably every agreement I see nowadays, is that, hey, this is your problem.
Hey,
Okay.
Roger, I just got an 83B election back in the mail today. I'm so happy. On the last day, on the 14th of May, accepted. Very proud of that.
Good. Well, congratulations. You don't avoided a tax disaster.
Yeah.
I'm going to talk about, well, let me just pause on acceleration now, and acceleration is the idea that you're a founder, you're saying, look, this is not fair that I have this 4-year vesting. If you sell the company in 2 years, and let's say it's a stock for stock deal, I shouldn't have to work another 2 years. I've done my job. I've gotten the company sold. So they'll say, I'd like you to vest all my shares on change of control. That's a change of control acceleration. Similarly, they might say, well, okay, I'll agree to the vesting, but if you fire me for no reason, just because we had 3 founders and 2 of you ganged up on me, then I don't think that's my fault either. I should get full vesting, or at least additional vesting. unless it's my fault. If you terminate me with cause, you can take the shares back, but not, I should keep them. That's another single trigger, termination without cause. You almost never see those. Often requested, rarely granted. For high-level executives, and not everybody, not your rank and file, you will often see double triggers, where if both of those things happen, right, the company gets sold and therefore your job is redundant because you're maybe the CFO and they already have a CFO, and you get terminated because of that, you'll get some additional vesting, maybe 100%, provided your termination is within 6 months or a year of the change of control. So, but again, that's something that typically has to be requested and only for more senior people. Here's the language for vesting: 25%, 1 year from issuance, and thereafter, in this case, it's monthly for the next 3 years. So after 4 years, you end up with, and keep in mind how we do this. It's actually a repurchase right at cost. Because the law abhors a forfeiture. So we have a repurchase at 0.0001, a triumph of form over substance, I'd say. But this is the typical language. Be careful about the language. You got to do math, and lawyers hate to do math. So this is one to look at carefully. Here's a typical double trigger language clause. See how it works. It says, look, if the bold part at the bottom is what I'd like to call your attention to. If our holder, that's our shareholder, is terminated without cause, or if you make it really hard for him to come to work, right? Okay, you make him move his office 100 miles away or something like that. Then in this case, it's within 12 months of a change of control, then all of the unvested shares automatically vest in full. Now, that 12 could be a different number, and that all of the unvested shares could be a different number as well. Other transfer restrictions that founders are going to agree to, just so you understand what these are. One is the ROFR, the right of first refusal. And this is the idea that the company wants to control who their partners are. The founders want to control who their partners are and who their other shareholders are. So it's really hard to, or let's say there's some legal ambiguity, and just saying you're hereby prohibited from transferring your shares. But it's really easy to say before you transfer your shares, you have to offer them back to the company at whatever the proposed transfer price is. And that effectively is a restriction on any secondary sales of stock, unless you get the company to waive it. Why do I say that? Is because who's going to want to come along and go to the trouble of doing due diligence and making an offer for your shares when you know the company's just going to buy them back after all of that? So it chills, let's just say it chills transfers. And you'll see that in every single founder stock purchase agreement if they've given it any thought. The other thing you'll see in every one of them is a lockup. And this is the idea that if the company goes public, that the founders are not going to sell their shares into the public offering until some period of time, 6 months typically, after that public offering. The only time I have never not seen a lockup in a founder's agreement was when the founder just happened to be a securities law attorney and understood what that meant and said, wait a minute, you mean the investment bankers can go out there and dump their shares in the market, but I can't? I'm not agreeing to that. But otherwise, I've never seen anybody else even try not to hit a lockup. So I would let that go, because the other reason is IPO is so far down the road. You got to pick your battles. This is not one I would pick. Now, let me give you a couple others that do pop up every once in a while in what I would consider to be really over-lawyered agreements. And I say over-lawyered because you will see co-sale rights, drag-along rights, etc. in stock purchase agreements. You'll see founders be subject to that once you have an investor come in. Before you have an investor, they won't. So by the time any of this matters, you will have an investor in a deal, if that makes any sense. So it's kind of like you're putting in place a bunch of restrictions that are all going to be rewritten anyway. And if you don't get an investor, like I say, none of this matters. But a co-sale right, you do see it pop up sometimes, though, because sometimes, I don't know, people want to do it for whatever reason. But maybe it's a preemptive strike. But a co-sale right is the right that a shareholder has to participate in a sale. So say I'm a founder shareholder, I found Bob wants to buy my shares. And before I can sell my shares to Bob, I got to go out to my other partners and say, hey, I found a patsy. He wants to pay actual real money for these shares, and I want to sell them. And the other partners can say, yeah, that's great, but they got to buy mine too. That's a co-sale right. A drag along right is the flip side of that. I want to sell my shares, but the buyer says, well, I'll take your shares, but I need Bob's shares too, because I don't want to be a minority shareholder. So if Bob has agreed to that and has given me that right, then I can force him to participate. As a general rule, investors get these rights, founders do not. But you will sometimes see some of this stuff negotiated, and depends on who your founder is. We'll get more into super founders later. Buy sell, I almost never do anymore. There was a time I made a real career out of doing buy sell agreements, and they were so fun. And hardly ever. A buy sell is the idea that, okay, you've got vested shares, but now you've left the company, or you've died, and I don't want your widow to be my partner, or you tried to gift the shares or whatever. You've gone bankrupt, and now I got to deal with a bankruptcy trustee. If any of that happens, I want a right to buy your shares at fair market value. You don't see that in startup land. You see that in closely held companies. And the reason you don't see that in startup land is, again, there's just not enough value there to haggle over until you get an investor. And at that point, the investor is going to dictate, all of this stuff. Rule 144 is a securities law related restriction that prohibits the resale of securities. So you can't do your own little mini private offering, public offering, for a period of time, typically a year after sale. So you'll just notice restrictions. They're security related. Again, pick your battles, not one to fight. Let's talk about others than founders, advisors, employees, and consultants, because you're going to be capitalizing this company. You're going to be bringing people on. Number one, what do you give them? Do you give them an option or do you give them stock? And we know what stock is, right? That's percentage share ownership of the company. An option is a right to purchase stock in the company. And it has optionality, meaning that you have this right to purchase stock at a fixed price that's set in your option agreement, and you can exercise that during the option term. So if the value goes up, you've got the benefit of that increase in value without having to come out of pocket at all. And if the value goes down, well, you don't take that risk. That's optionality. So that's an option. That's how employees are typically rewarded in a startup, because it's, you don't want to take their money and issue them stock, and then they take a lot of risk. You'd rather give them the upside, but not the downside. Vesting, we talked about. Options can vest just like stock. Just keep in mind, because this comes up once in a while, you do not make an 83B election on an unvested option, because there is no transfer of property. When that option is exercised, if it's unvested, and if the option agreement allows it, yes, then you will make that 83B election. So I'm going to talk about timing later. So advisors, this is more lore than law, but typically an advisor is not a consultant. It's not an employee. It's somebody that you're bringing on for one very specific area of expertise. And usually it's relatively short term. So typically I see 2-year vesting for advisors, and I see their vesting also tied to that milestone or deliverable. I'm going to get you 6 customers. I'm going to introduce you to this many people. I'm going to get you to tape out. I'm going to get you to this technical milestone, this FDA approval, whatever it is. That's the milestone. Then you vest, and you better do it within 2 years. And that's where you will see single trigger acceleration sometimes, because your acquirer, they are going to have no need for your advisors typically. So it does sort of make sense to let them vest if that happens. I just want to give a nod to the FAST model, which has been downloaded hundreds of thousands of times. You'll find it online, and it has a kind of a cool little matrix attached to it that will give you an idea of how much stock to give to, or how much equity, what percent of options or stock to give to an advisor based on what they're going to do, the stage of the company, and their level of commitment. So it's a nice, neat tool. Now, let me talk a little bit about options. And well, I'm going to jump ahead. So the option plan, remember the option is a right to buy stock at an exercise price, sometimes called a strike price, which is equal to the fair market value on the date of grant, right? So back in the good old days, we used to grant options, at way less than their value. And we'd all kind of hold our nose and hope the SEC doesn't beat us up about it. And if you didn't go public, they didn't. And you'd hope the accountants would not beat us up with a big earnings charge, but if you had a good accountant, they would. And anyway, that was the practice. It was kind of like it's one of those that's Hollywood kind of things we did in Silicon Valley. For the last 20 years or so, 2003, I think it was 2005, somewhere in there, the law changed, and now an option really has to be granted at fair market value on a date of grant. And the best practice is to have that valuation supported by a professional valuation. They call that a Section 409A valuation. So no more cheap stock, and you got to get this professional valuation. And the market, although if you read the language carefully, there's technically some wiggle room in that, but the market practice is that no one's going to invest in you without it. No acquirer is going to let you get away with it. They'll make you cancel your options. You got to have that professional valuation. The good news is it's become somewhat of a commodity. It's relatively affordable, but it might not give you the number that you want. So it's not going to be the penny options we used to do. It's going to be the real value, to the extent that value can be real. The two types of options you'll see in your plan are ISOs, incentive stock options, and NSOs, non-statutory options. And the difference is that ISOs are for employees, and there's this tax benefit. And here's the tax benefit. If you're an employee and you hold an ISO and you exercise the ISO, you don't get taxed on that exercise. If it's an NSO, you get taxed based on the difference between what you pay for the stock when you exercise and the value. That's compensation income. That's a real disincentive. That's why nobody exercises NSOs unless you've got a really good reason, like they're about to expire. ISO, Congress said, let's give employees a break on that. Let's say that you won't get taxed on exercise. And if you hold that ISO stock for a year, more than a year from exercise and more than 2 years from grant, we're going to give you capital gains treatment when you sell on the back end. So ISOs have special rules. And of course, Congress gives and Congress takes away. It's subject to all sorts of special requirements. It can only be granted to employees. Has to be exercised within 90 days of termination of employment. Has to be at fair market value for certain. For 10% shareholders of the company, or 5% shareholders of the company, it's got to be at 110% fair market value. So there's all sorts of restrictions on this. So keep that in mind. You're going to see ISOs. Oh, and there's special reporting for ISOs as well. But those are the two kinds of grants. I will tell you that almost always I just do NSOs, even for employees. And the reason why is because nobody's going to exercise ever until the company exits, usually. That's just a general rule. And at that point, they're going to get cashed out and the tax is going to be ordinary income anyway. So why go through all the pain of tracking ISOs? That's the simple answer. If you want to live with the complexity and people want to do this stuff, they can get a better result. Federal Rule 701, let's not forget about it. The reason we have an option plan, you're probably wondering, why don't we just give stock to all our employees? Why do we got to have this fancy schmancy option plan that I got to pay you for and get a 409A for? Well, we're trying to avoid securities law violations. And there's a federal rule, it's a blanket securities exemption for employee plans. And the option plan has to fit within that exemption. I'm not going to go all the details of what that is. Just suffice it to say that there is a federal securities exemption. That's why we do this. And it has some limitations on how much of the company can be out in these plans and what sort of information has to be given to optionees. Similarly, we have state securities laws, and we can't forget the California rule, because California, if you have one optionee in California, that requires a notice filing. And the good news is it can be filed late. There was a time when you couldn't file it late or it was meaningless. Now you can file late. The bad news is if you don't do it, the state of California will track you down and penalize you. And then finally, all of this does require board and shareholder consents. That's a lot of work. So, oops, wrong way. So for a startup company, instead of just putting a plan in place and granting the options, instead what we'll do is we'll give them an offer letter that says, look, unless we get funded, none of this matters. So how about this? We will grant you an option when we get an option plan, which will be after we can afford a 409A, which is when we get funded. And that's the standard in the Valley, and that's what we typically do. We have this kind of language, but that's why we're doing it. Couple more words about options. We talked about termination. Sometimes you'll see a bad boy clause in an option plan. Rarely, almost never on the West Coast, sometimes on the East Coast. And a bad boy clause says, look, if we fire you for cause, you not only lose your unvested options, you lose all your vested options and your vested option stock as well. Just be aware that I'm seeing that pop up more and more now. In fact, even on the West Coast, I am. One point, we talked about 83B. Notice that in order to get this 409A favorable rule, we could spend an hour on it. I won't. I'll just tell you that an option has to be granted on common, not preferred. Okay. I did see an option plan once. I don't know why they had an option plan on preferred, and unfortunately that does not work. And then finally, on exit, what's going to happen to your option, right? And a well-drafted option plan is going to say, depends, depends what the acquirer wants to do. They can cash you out. They can assume your option, so it still exists. It's just now you got a new employer. They can substitute it with their own option, or maybe they just terminate it, forcing you to exercise before they terminate. So you want to pay attention to that if you're an optionee. Okay, getting into some additional common stock issues. There is this thing called Class F super voting stock that comes up, 10% of the time. And this is the idea. You have a bunch of founders, but one founder is the main guy, and he really wants to maintain his control over the major decisions of the company, but he doesn't have the shares. He's got a third of the shares, but he wants 51% of the vote. Well, what we can do is we give him super voting rights on. So he's got Class A common, everyone else has got common, and the Class A gets a 10-to-1 vote for every share, and that allows that person to maintain control for a long time. I generally try to talk people out of that because your VCs are just going to negotiate that all the way because it's just too complicated. And they don't like the idea. Not always, but for example, Facebook, Google, Snapchat, I guess if you're one of those founders, you can get away with all sorts of super voting stuff. But if you're not a superstar founder, you may have a tough time hanging on to that. So I just ask people to pick your battles, decide if you really want to pick something like that, you're going to have to fight about later. But I do want to mention that it's out there and I see it a little less than 10% of the time. Let's move on to investment. Next, I think it's next month, but in actually a couple of months, we're going to be having an entire hour on venture capital terms. So for now, I want to hit the high points of taking in the early money. Founders, friends and family, angels, seed funds, venture funds, which Bob does. Just a nod to non-dilutive funding, bank debt. They will ask, your bank may loan you money. It's going to ask for security, probably a house, maybe your mortgage or a personal guarantee. I really, really, really discourage startup founders from doing this for two reasons. Number one, you don't want personal liability for a startup. You just do not want to be hanging out there on a limb for this stuff. And number two, if you're the kind of company that can even get bank debt, because the bankers I talk to these days after Dodd-Frank, they want to finance, they want to make loans based on income, then you're probably not a candidate for venture. I mean, if you're generating cash flow, you're not reinvesting in building a big asset. And that's a humongous generalization. I understand. But just keep that in mind. I just don't see it, not never, but not often. Now, having said that, I just did a deal where we did a bank line of credit followed by a Series A within a month. So it does happen. So I don't want to say never, but for my earlier stage companies, not that often. Government money, that'll be a different presentation by a different person, but that government grant money is out there, and there's more of it than you might think. It's just a lot of work, is what people tell me. I don't do that. And then finally, we used to talk a lot about crowdfunding, not so much anymore. Think of it as a pre-sale. Let me just put it that way. So, yeah, if you can sell products to raise money, boy, that's the best. That's the best money to raise. Okay, let's talk about founders. Most founders are going to put their personal savings into the company. By the way, when you do that, we talked about this last month, make sure you get paper back, either a safe or a note or additional stock or something that, we talked all about it last month. I won't reiterate, but founders do put money in and you should document what you're getting for it. And even if it's nothing, you should document that. So we're going to go over this in our venture round. So I want to move along to the friends and family. A lot of founders raise money for, I think the number's higher than 38, but that's my last data. Will raise these small amounts of money just to get going. So I want to just get into, we talked about this last month, but I want to reiterate it again here today because it is so important. We want to hang on to this QSBS exemption. And every time the company issues stock, it ought to be thinking, is this QSBS? And did this transaction affect our QSBS status for anybody else? And remember, qualified small business stock, it means that if somebody gets issued, even a founder, investor, optionee even, if they get stock in a qualified small business, they hold it for 5 years, they sell the stock, they get an exclusion from federal gain, a tax exclusion from federal gain up to $10 million or 10 times basis. So it's a huge exemption. We talked a lot about it last week, so I won't mention it again other than to say, just be careful. And the one way you mess this up is, well, two ways. One is through secondary sales, and secondly, through redeeming stock. So be super careful. Okay, now what everybody came for, the main event, safes and notes. This is how the early money goes in. And convertible note, as we know, that's just a debt obligation. I'm going to borrow money. I call it the wimpy solution from the Popeye series. If you give me a cheeseburger today, I will gladly repay you on Tuesday. So you give me the money today and I'll gladly give you stock when I do a financing. That's the convertible idea. Convertible note, it means that the note will actually get repaid with interest if we don't convert to stock, if we don't do a financing. That's a bit of a fiction because if a company doesn't do a financing, it probably can't repay the note, but it still has those features. A couple of concepts, and it's usually worded differently, whether it's a note or a safe, but there's this idea of a valuation cap. And that's the idea that, look, you're worth $1 million now. By the time you do a financing, you're going to be worth $40 million. So I don't want my money that I'm giving you now to convert at a $40 million valuation. I want it to convert at something less because I'm getting in early. And it's got to be more than just 20% less than what the investors are paying in your 40 million valuation. So we'll put a valuation cap and say, look, no matter what happens, you're going to get at least this percent in a company when we do our financing. That's a valuation cap. Almost every instrument I see has this these days because everyone's been burnt once by not asking for it. Discount, it used to be every instrument had a discount. If you put money in now, you get in at a discount, usually 20% to what the investors invest at. That's going away. I see less and less of that now. And it's because the dominant market player has just one day declared that that's no longer market. So, okay, whatever you say, I still fight for it if I'm an investor, but I will say I'm seeing it less and less. Some other common features of the safe, what happens if we sell the company before we do a financing? Well, usually it's one of two things. Either you get, 2 times your money back or something like that, or we convert you to common at some valuation and you get stock based on that. A couple other concepts, shadow preferred. We do a financing. We're going to convert our safe or our convertible note into stock. And remember, I said we're getting the same stock that the investor's getting. Well, not really, because we're paying a different price for it. So we can't say it's the same thing. So there's a shadow preferred for every class of safes. And these days, and every class means every different valuation cap, every different discount rate, whether it's pre-money, whether it's post-money. So these days, a typical Series A financing or even a Series C financing is going to have multiple classes of preferred. They become very, very complicated because of the ubiquity of safes. MFN is most favored nation. Smart investors will say, look, I'll go along with whatever egregious document your lawyer drafted up, but if you make anybody else a better deal than I've got, I get those terms. That's an MFN clause. And pro rata rights used to be built into the document. Now we put it in side letters, but it's basically the idea that I'm entitled to maintain a certain percentage of this company by investing more money if I want to. Your later investors will hate that, and you'll have to negotiate with them. I'm going to pause on this pre and post money for a minute because that's a longer discussion. The difference between safes and debt, and I have to talk about it because there still is, just this morning, I saw a convertible debt instrument. It's still out there. Typically, it's got to be short term. A safe could be out there forever, but for regulatory reasons, you'll see convertible debt maybe a 2-year term, usually one. Debt can be secured if there's anything to secure it. It can be subordinated or senior if there's anything. Safes are not debt, so they sit in the equity stack like preferred stock, so they don't get any of this stuff. Debt gets interest. It has to, otherwise it's not debt. Well, it could be debt. I guess it could be non-interest debt, but then the IRS will impute a rate. Safes do not have interest. There's a fixed repayment if it's debt. A safe is you're going to get, whatever you get, whatever it converts into. The discounts we talked about, the valuation caps we talked about, same concept. And with debt, you will often see warrant coverage because a lot of times if you see debt, you see a troubled company and you see warrants. A warrant is a right to buy additional stock at some price. And that price is oftentimes a penny. So it's like you're giving them additional stock for them giving you the money. Okay, now I want to drill down on safes because that's what we do out here in California. Now, two basic kinds, the post-money and the pre-money. Let me just say that the post-money tends to be investor favorable. The pre-money tends to be company favorable. And this is why. The post-money safe, the percentage ownership is basically fixed. It's like, look, I'm giving you my 1 million on a 10 million post. That means I'm going to get 10% of this company before the next price round. This is before the venture money comes in, when the safe converts, but regardless of how many other safes you sell, right? And I don't care if you sell $100 million of other safes, I still get my percent. That's a post-money safe. Okay, so you can see that in the extreme situation, that would be a very bad deal for the company. But the idea is it's way simpler to calculate. And remember, lawyers don't like math. And it also is, it's also probably not that big a difference if you're going to use that safe as a bridge. In other words, if you don't plan on selling tons of safes for a long period of time until you finally get to that valuation. Now, the pre-money safe, it is just the opposite. It converts into stock based on a cap table prior to the safe conversions. So if I have a pre-money safe, I get diluted by all the additional safes that are there with me. And I'm going to show you some real numbers in a minute. There's also a subtle tax difference. Everybody treats these safes as stock, and they claim to qualify small business stock treatment for them. I will tell you there's a much stronger argument for treating a post-money safe as stock than as a pre-money safe. And the IRS has not ruled on any of this. And when they do, I suspect they might come up with a different answer between the two. So don't say I didn't tell you. But as of now, they haven't ruled and people are taking that position. Every accountant I've talked to is comfortable with it. So just so you know. Let me give you just to put some numbers to it. And I know these are super simple numbers, but I just want to make sure we understand the point. I got a pre-money safe. Let's say we got a company, we've issued 4 million shares. We don't even have an option plan yet. And I want to get my pre-money safe $4 million pre-money valuation cap, and $1 million safe. That means I get 20%, right? Because it's pre-money, 1 million divided by 5. On the other hand, if that's a post-money safe, I get 25%, right? Because it's 4 million, 1 divided by 4. So that's a simple example, and that's the basic idea, and it gets mind-bogglingly complicated once you start getting, into the details, and you get additional safes, and then an option pool increase, and then, et cetera. Okay, moving right along, we're going to go a little over. I hope that's okay for everyone because there are some important things I want to cover. Series seed stock. Sometimes people will say, "Look, I don't like these convertibles. You got a million ways you're gonna get me. I just want my stock. I want to buy stock in this company right now, and we don't have to make this a big deal. We're just gonna do like a really weak preferred." Now, we are going to have a whole hour on preferred stock, so I'm not going to spend too much time on it, but I will say that this option is out there. Sometimes you will just give people a very simple weak preferred. It doesn't have like registration rights, it doesn't have co-sales and drag-alongs and all this stuff. Maybe you give them a board seat, but it's a very simple standardized, and it is standardized. There's standardized documents out there for this. So keep that in mind. If you want to go just right to stock ownership and keep things simple, you would do series seed stock. It differs from common in that it has a preference. In other words, preferred gets paid first and then common gets paid unless the preferred converts to common, or if it would get a bigger amount if it converted, then it just gets its pro rata percentage. That's what preferred is. I just want to mention a couple of traps before we leave this. Number one, well, we've talked about it. The post-money safe, it can get you in trouble if you have a lot more of these than you expected. And you really, the cap tables that are out there now, the cap table tools, the commercial tools, they have features in them where they'll let you do pro formas or what ifs. You'll want to do the pro formas, you'll want to do the what ifs, you'll want to know where you stand on your percentage ownership on a fully diluted basis from time to time. So be careful about that, because I've seen it happen over and over and over where the founder is just selling safe after safe after safe with these low valuation caps, and they didn't realize how much of the company they gave away until the equity investor came along. We run a pro forma, and it's like, holy cow, that's all I got. It's no longer worth it to me. I'd be working for the investors. So just keep that in mind. Second big thing is it's so easy to go online and download a form and fill it out and take the money and not realize that you've just sold a security. And I can introduce you to people who are sitting in prison for unlawful sales of securities, right? This is a law, and it's a very serious matter. And it scares me to death, to hear that people are out there doing this stuff, because there's a million ways to die here. And I think we may have talked about, if not, we're going to in a later session, on what securities fraud is. And you will be surprised to find out that securities fraud is a lot broader than you might think it is. And then secondly, there's securities compliance, right? There is a federal form that should be filed, right? It doesn't deny you the exemption if you don't, but it's a safe harbor. And there are state notice requirements that must be filed that nobody does when they do it themselves. So this is one of those things we have to clean up. So it's going to cost you money on the back end if it's even subject to being fixed. You might have to, I've been in deals where we've had to do a complete rescission, what we call a rescission offer, and that's messy and expensive. So just be careful of these. And then we'll talk more, and then we talked about the cap tables and how we should map these out on a pro forma. I want to drill down on a couple of federal securities laws issues before we finished. So the general rule of securities is every sale of securities has to be registered or exempt. That's the federal rule. And generally, you want to sell to accredited investors, right? And accredited means they have $1 million net worth or they meet an income test. And that used to be a really hard test to meet. And by the way, that net worth test excludes your personal residence. It's a lot easier test to meet these days. And there's two flavors of accredited. One is 506B, non-public offers. So you just have to reasonably believe that the investor is accredited. You don't have to verify, but you cannot solicit or advertise. All right. And then there's a 506C where you can advertise, you can generally solicit, but then you have to verify that the purchasers are accredited. Now, that verification rule just recently changed. And before we get to crowdfunding, there's a new rule on verification that says, look, if an individual has put $200,000 into your company, you can rely on that. You can rely on that as evidence that they are accredited. Or if it's an entity that put $1 million in, you can rely on it, provided they give you some written confirmations, do some paperwork, etc. And that's huge. That makes the verification process so much easier. Now, this is for 506C. I think this is good evidence for 506B. If somebody's going to invest that much money, you should probably feel pretty good that they're accredited. That's what the new rule says. Crowdfunding, we could talk a lot about that. You can raise money, and that's the right answer for a lot of companies. And we'll do a security session where we'll cover this in more depth. I want to mention it now. And the new, what they call Regulation A+, which is like a mini IPO, you can raise, 50 million that way. So there are other ways to raise money other than the usual angel rounds. I do want to mention state blue sky laws because, again, it's so easy to mess this up and to forget. And you can have something that's exempt from federal registration, but still you got to comply with the state. And California is the poster boy example of this because California is one of those states where an offering can be perfectly legal federally, but you can't do it as a state matter because we have a sophistication requirement for most offerings, which is not hard to meet, but it is there. That's 25102F. It also requires a notice. And a lot of other states have notice filings at all. We have to check every state whenever you're selling securities. I am almost ready to close, but I want to mention a couple of other gotchas before we leave. One is broker-dealers and finders. A broker-dealer is somebody who's authorized to go basically raise money for you, but they register with the SEC and FINRA. And there are these things called finders, unregistered finders out there that will go out and introduce your company to investors. They'll raise money for you. As far as the SEC is concerned, if they're getting a success-based fee, meaning a percentage of the funds raised, then they are a broker-dealer and they are subject to regulation. That's been their position, and that is their strong position. It always has been. So keep in mind, this is a hard thing to do. Now, we would have to, there's ways to craft into a finder relationship, but you can't use success-based fees as an example without violating the SEC's view of this. If you do violate this rule, you might have to give the money back, might blow your securities law exemption, and most importantly, the founders could have personal liability on this. I know that's a little bit of a stretch, but it could theoretically happen. The last thing I'm going to talk about, because a lot of you are going to go to pitch competitions, and everything I've just said about public offerings, you're saying, well, wait a minute, I go do demo days and it's all out in the public. Anybody can, and I host demo days too. So I know the drill. Well, the trick here is number one, to limit it, so that it's not just open to the public. And secondly, if it is open to the public, it can be a demo, but not a solicitation security. So I always counsel people, if we have if it's public, don't be telling people you're raising money and this is how much you want and this is what they're going to get. Tell them about your awesome product and how you're going to change the world and stay out of trouble. Okay, that's been about an hour. My name is Roger Royce. I'm a partner with Haynes Boone. There's my email address. You'll be getting an email from me. I'd invite you to take a look at one of my two books, or both of them, if you'd like to drill down. Dead on Arrival, How to Avoid the Legal Mistakes That Could Kill Your Startup, and 10,000 Startups, which I wrote during COVID, Legal Strategies for Startup Success. So thanks, everybody. And I'm going to stop the recording and stop the share at this point.